my name is Africa, and I'm with ABK Creates, a creative studio located in Washington, D.C. And we're very pleased to kick off our very first Tuesdays office hours. And today we'll be talking about intellectual properties. And as a creative, this is very important. This is vital to the life of your company, your brand. And we have an expert that's going to be talking with us. This is going to be a great, lively discussion.
I want to thank you so much for inviting me to talk with you and your community about this very important and really exciting topic, intellectual property. My name is Shayna Jones McGrone. I am the founder and managing attorney of ArtistinLaw. My law firm specializes in business law, in intellectual property, as well as business succession and estate planning. ArtistinLaw really is the law firm for creatives. So we help and work with creatives, those seen as the traditional fields of being creatives, writers, filmmakers, musicians, in order to protect and monetize their intellectual property. And we also work with those other individuals that sometimes I see as being the most creative people on the planet, entrepreneurs, and helping them to make sure that they can flourish and grow. My business is really about helping folks to make their vision into a reality and helping them to create the life that they see in their minds.
Okay. So if we can just jump right into it and kind of give us a little snapshot of 101 on intellectual properties. So what is intellectual properties?
So intellectual property are really those creations that come from your mind. That's what IP means. And there are various types of intellectual property, as defined by the law. Generally, we're talking about trademark, we're talking about copyright, trade secret, and patent. And there are various laws, federal as well as state, in order to protect those different types of intellectual property.
Okay. And you mentioned state and federal. Can you go into the differences in terms of protection?
Absolutely. So there are certain things that are regulated initially at the federal level, and then there are also state rights that come with those. So most states will have protection for your trademark. For example, you can register a trademark with the state. They may have some form of a copyright protection, but really the gold standard for protection for any sort of individual that has a creative property that they've created is going to be at the federal level. So let me take a step back and let me break down those 4 types of intellectual property that I just mentioned and kind of give some examples. And then we'll talk about, the agencies at the federal level that regulate them. So when you're talking about a trademark, that really is a brand name, That is something that is supposed to signal to the public that a certain type of service or product is coming from this particular source, so that the public is aware that anything marked with that name is coming from that same place and they can identify the quality. So let's think about some famous brand names: Nike, Coca-Cola. You're aware that anything that has that mark on it is coming from that particular company, and you assume the level of quality is going to be. When we're talking about patent are those inventions, right? They're scientific processes that are protected. For example, an invention, as I mentioned, or really, a vaccine, right? Talking about COVID, that's something that can be protected by patent as well. Both trademark and copyright are protected by the United States Patent and Trademark Office. That's the office that you go to in order to register those types of creations and inventions. So copyright are those sorts of creative works that oftentimes come to mind when people think about IP. You're talking about books, songs, websites, right? Those sorts of things. That's protected by the United States Copyright Office. And then the last one, trade secret, is often the one that is the one that's less commonly known about. So trade secret, those are really those things that You don't want individuals outside of your organization or outside of yourself to get a hold of.
And that's a good point, because we do have some bakers that are within the community. And so if they do have a recipe that's been handed down for years and years, what is the best way to protect it?
So that's a really good question.
Mm.
And often what you're going to want to do, you need to put some policies and procedures in place to limit who has access to those things.
Okay.
And that's one of the things that my firm helps people to work on.
Mm.
How is the recipe kept? Who has access to it? And when and why do they have access to it? Those are
Oh,
going to be some of the questions that you're going to answer or want to answer in order to make sure that that secret is really kept secret. And what agreements do you have in place with those who do have access to ensure that they don't make the trade secret known publicly? And if they do, what are the consequences for that?
so when I was on your website, I was looking at it, and I was very intrigued by the fact you had some information that says ways to protect your intellectual properties, and it's register, maintain, and monetization. Can you break down those three?
Absolutely. So the registration process refers to those steps that you need to take in order to file with the federal agencies. I'm going to talk
Okay.
mostly about federal. There may be some cases where people want to file statewide, but mostly we're talking about federal application, and that's what I'm really going to address here. So registration is that process of filing for protection with the federal body. So once again, if you're talking about trademark and patent, that's with the United States Patent and Trademark Office. If you're talking about copyright, it's with the U.S. Copyright Office. And of course, we already talked about trade secret being policies and procedures within your organization, or if it's just you that you observe yourself. So you need to go through that application process. That's the registration process. So for any sort of intellectual property, there's maintenance. It's not just do it and forget it.
Okay.
Trademark requires that you have continuous use of that brand name and that you demonstrate to the USPTO from time to time that you are continuing to use it and reapply for the right to continue to use it.
Oh.
For copyright, the copyright scheme lasts for a significant period of time. Now, copyright generally, even once you create the work, you have protection through the U.S. Copyright Office.
Mhm.
But if you want to engage in some form of infringement action, if someone is using your copyright and you want to receive the statutory award, if they are found to be infringing, you need to actually be registered with the office.
Okay.
So that's one of the main reasons you register copyright, right? So once you do that, the copyright lasts for the life of the author plus 70 years. Okay. So it's generally a long period of time, but during that time, you're going to want to be monitoring to see what's happening with your mark, to see if anyone is infringing. And it's the same thing for trademark. Are you doing the work to ensure that no one is actually using the thing that you've created and that you are supposed to have the exclusive rights to determine how it's used for the time you have exclusivity over it? Now, for patent, I do not do patent specifically, but what I can tell you is that there is a lifetime, I think it's generally about 20 or 25 years, that a patent holder will have on a patent so that they have exclusive rights to it. So, for example, for a patent, you'll hear that a pharmaceutical company will have exclusive rights to use their formula for maybe 20, 25 years, and then you can come out with the generic.
Okay.
Right? So that's when the generics come about once that patent right is no longer in force.
Mm-hmm.
So that is the registration, that's the maintenance, and then really the fun part is the monetization. So of course, when you want to talk about arts in the pure form, you create the art because you believe that you have something beautiful to transfer to the world. Right. Or you create the brand because you want to bring something to the world. At the same time, as a savvy business owner or a savvy creator, you want to make money off of it. Of course, one of the initial ways that you monetize your creative work is, the actual sale of it. Right. So if you're a photographer and you sell the photograph, right, that's a monetization. If you perform some sort of a service, right? So for example, I'm an attorney. My marks are trademarks as well, right? I'm performing those services under those marks. That's some monetization of my brand. And of course, we already know about, patent and the use of
Right.
inventions, right? But then there are other ways that you can do that. For example, do you want to license your marks? Are there ways that you can make money from your brand, from your creative work, without you necessarily having to put in all of the work?
Right.
Right? And so those are some of the tasks that you're going to want to go down, or some of the routes that you're going to want to go down in order to really make your creative work for you.
And that's more of, I guess, a business strategy approach that the creator has to start thinking about, how to make money.
Absolutely.
That's the goal nowadays. People want to make money while they're asleep. And so if you can do that through licensing, that's
Absolutely. And licensing is one way to do it. There are some other creative ways too, but it is all about your particular business strategy. What do you see your business doing? How are you looking to exit? Those sorts of things.
You mentioned international protection. I know there isn't like an international intellectual property law, but we do have relationships with other countries that will sort of protect. Can you explain that?
So there are various international protocols in order to make sure that your mark is protected in an international market if your mark is being used internationally. Okay. So one of the largest bodies or largest protocols is called the Madrid Protocol, which is a system that allows for you to file almost seamlessly in a number of countries abroad if your mark is eligible for that sort of protection. There are also other types of regional bodies, and then there are also country-specific bodies. So that's also about strategy as well. Where are you using your mark? Where is it necessary to file? And what's the easiest and most viable body to use in order to get that protection?
Okay.
So that's one, that's for a trademark. And then there are other procedures for other types of IP.
And that's why I'm glad we're having this conversation, because I think a lot of times with creatives, we are so eager to get the creative thoughts and ideas out into the world and on paper, and we don't necessarily think about that next step. It's like, you took so much time to create this, and now you want to protect it. And these are the ways that our system has, created to protect it. So why not take advantage of that? So
the thing, Africa, is that when you're a creative, when you're a business owner, it really is a combination of things, right? It's a combination of you creating and putting out the thing that you actually do, but it's also a marriage of that business side. So, for example, with my law firm, right, my business is to work with people on the legal front to protect their businesses, to move them forward. But there's still also that back end stuff that goes into running a business. Is your accounting done well? Are you marketing? Do you have processes in place? Are you contacting people when you need to? And so it's never just just this one and done thing. It's several things. So is it going to be handled by you, or is it going to be handled by someone else? No one's saying it has to all be done by you, but you do have to understand that it is just more than you doing the thing that you do, and taking the proper steps to do what you can, and also create a team around you that can help you with those other things that are necessary to make sure that you succeed.
I guess getting into the social media side, what should social media influencers know about protecting what they're creating? Is it pretty much the same that we've already discussed, or is it little different nuances?
Yeah, so it's a lot of those same things. Social media influencers are, if we're going to have a brand that they want to protect, they're obviously going to have a lot of, copyrighted works with their videos, so on and so forth. And then there are going to be certain other, kinds of standard, or not standard per se, but other types of documents that are going to be necessary. If you're running a website, you're generally going to want some terms and conditions, a privacy policy, maybe some advertising disclosures, right? So there are some other things that may go along with social media work as well, but you're still talking about the general, IP frameworks or frames that we've already addressed.
Okay. And you mentioned documents for the social media influencer. What are those easily accessible in terms of like the terms and conditions on your website? Are those easily accessible?
So,
or do you need an attorney to have someone draft?
Right. People have to address things according to what their resources are. So of course you can go online and you can find form documents for various things. But understand a form is exactly what it says.
Mhm.
It's been created or drafted broad enough to fit so many circumstances. But that doesn't mean that your circumstances are those circumstances. And it doesn't mean that whatever is in that document is the only thing that you need in your business for that document. So, for example, someone who has an e commerce website might need one set of terms and conditions versus me having a law firm may need something completely different.
Right.
And a form document is probably not going to address that.
Mhm.
So, if when you start, if the only thing that you can deal with is a form document, of course, I completely understand that. But it's always going to be best to go to a professional who really can work with you specifically on what you have and what you need. At
Okay.
my law firm, we don't do anything form
Mhm.
because
Mhm.
no two people are alike, even if they're
Right.
in the same industry. And the point is to create something that's going to work for your business or for you as an individual creator when you need it.
If you can
Yes,
kind of go over like what public domain is when a
sure,
property goes into, yeah, public domain.
sure. So the public domain so when you're talking about specifically the public domain, you're talking about when copyright falls out of IP protection or those exclusive rights that go to a copyright owner. And like I said, that's going to end after the life of the creator plus 7 years
Okay.
in one instance. So once something falls into the public domain, that means that basically anybody can use it and exploit it in any way because it is open to the public. So it falls into the domain, as I said, after the life of the author plus 70 in one instance, or someone can decide that they want something to be in the public domain once created. There are things created such as the public commons.
Mhm.
There's a lot of computer code in the public commons. And there are certain other documents in public commons as well, where the creator has simply decided, no, I want everyone to be able to
Okay.
use this
Access.
right now,
Mhm.
right? So that's another way that something can fall in as well, right? So really, in general, the point of IP, just going back to the broad scope, is really a balancing act of two things. It's allowing the creator to have exclusive rights in order to use, exploit, monetize their creation, but
Mhm.
at the same time also allowing the public to benefit from the creation of those goods. That's the particular balancing act in the United States. In Europe, there's a different balancing act that they use. So,
Do you think the IP protections that we have currently are strong enough, or do they need to be strengthened, or in
so
terms of?
that's a
Oh,
really good question. So I think that the scheme in the United States is actually very robust.
no.
Um, there, I do think that when creators engage in the protection of their IP, they have to understand that it is a right that they have to actively engage in addressing. You have to actively monitor your
Mhm.
creations. You have to make sure that no one is infringing upon them. You have to actively protect them. And if someone is infringing upon them, be willing to take some steps in order to redress that.
What are the steps at that point once you realize that someone is out there using your brand without your permission? I mean, I know you go to an attorney. I mean,
Sure.
is it a long process, an arduous process for the creator?
So so first let me say this. There can be infringement on any type of intellectual property. You can infringe on someone's trademark, copyright, trade secret, or patent.
Mhm.
It's not just limited to patent. And there are several procedures that you may want to undertake, and that really is a strategy decision as well.
Okay.
So, for example, on a trademark or a copyright infringement, really all of them, one of
Mhm.
the first things that you might want to consider doing is a cease and desist letter.
Okay.
Um, for certain types of copyright infringement, for example, if it's happening over the internet, you may be able to use a DMCA takedown notice. DMCA stands for the Digital Millennium Copyright Act. So every website provider has to have a scheme for taking down works that are seen as infringing by a copyright owner.
Okay.
So that's one way to do it. Uh, there are, for example, for a domain name infringement on trademark or something like that, there are international bodies that will address those things and have domain names turned over to you if they actually really have to do with your brand name.
Oh, okay.
And and then you come to the determination of whether or not you want to engage in some form of an arbitration, take some form of a judicial or extrajudicial act, right? Some form of an arbitration, a mediation, or a lawsuit.
Mhm.
So, any of them can be costly, but really what you're weighing is what's the cost of allowing someone to profit off of all of the hard work that you've invested in your brand, right?
Mhm.
That's one thing. And that, and what your resources are may be a determination for the type of strategy that you undertake in order to address an infringement.
And then I have one more question for you, Shayna. How
Yeah.
did you get involved? Like, what inspired you to be an attorney and to focus on this particular area of law?
Oh my gosh. Yeah. So I knew from quite young that I wanted to be an attorney. Um, I started my legal career. So I've been an attorney for 14 years. And I started my legal career as a public defender. So I was a criminal defense attorney for indigent clients. I worked with the Defender Association of Philadelphia. And I got to do exactly what I wanted. I went to a law school that was specifically a trial law school,
Oh,
one of the best trial law schools in the country. I went to Temple Law in Philadelphia. And I was blessed to go where I wanted to go. I wanted to go to the Defender Association. I wanted to be a public defender, and I did that. And through that process, I got to see what I really enjoyed about the practice of law and what I didn't enjoy.
mhm.
And, you get to meet people and help people in crisis as a PD. You don't get to help them to plan not to be in crisis, which is really what I think I'm really good at.
Mhm.
And I learned that through my 4 years there. And I also am a creative person. I've always liked to, I've always been an avid art lover. I've always been very into producing things, events, shows, that sort of thing. And so I decided that I wanted to take a turn in my career and really direct my own life. I went back and I got my master's of law degree in intellectual property, which is a postdoctoral law degree, a specialty in that particular area. And I shifted on to doing transactional business work after doing some business litigation work.
Oh,
So really helping people put their businesses together, combining that with, my IP degree and helping them on the IP side. And then I took some additional training in the estate planning business succession work to really try to have a well-rounded practice.
okay.
And I've been doing that for the past, you know, five years or so.
We're winding down now. I want to thank you for your time today. Just tell us how we can get connected with you, as well as, once again, what your law firm does, because I know we're going to have some creatives that definitely want to reach out to you.
Absolutely. So, my firm ArtistinLaw helps creatives and business owners in areas of business law. So, we're talking about business formation, looking at your agreements, negotiations, in the areas of intellectual property, specifically with trademark, copyright, and trade secret. And we also help business owners for figuring out how they're going to exit their business and plan for the next generation in the areas of business succession planning and estate planning. So we try to make sure that for the lifespan of your business, you have solutions with us.
Mhm.
And it's really about a holistic view of what's going on. Are you able to properly protect what you have, monitor it, um, monetize it?
Mhm.
Whether we're talking about, IP specifically or other forms of business protection. And the ways to contact me, my law firm's website is artistinlawfirm.com. We are on Facebook, Instagram, Twitter, and LinkedIn. On those platforms, on Facebook and Twitter, we're under Artisan Law. I am specifically on IG under Shayna Jones Esquire. On IG, we're under Artisan Law Firm. And on LinkedIn, you can find me specifically under my name, and my company page is linked there.
Oh, So thank you so much, Shayna. I really appreciate you spending time with us today and sharing your story. And I've learned quite a bit. I've taken some notes, and I know that our audience will, walk away with a lot of knowledge. And I know we will definitely be connecting again.
Absolutely. This has been awesome. It's been so great talking to you.
But thank you so much, and have a good day.
Absolutely. You too.